Affirmative action before the bench today. The High Court is considering whether the Constitution's guarantee of equality allows public schools to use race as a factor in admissions. With us from Washington's Mark Agrast. He's a senior fellow for the Center for American Progress. I thought we settled this issue decades ago.
Well, I don't think we did settle it. We had hoped that we had. When Brown versus Board of Education was decided, it was hoped that that would lead to a race-neutral society in which we no longer have to think about these matters. I think we've learned in the last 50 years that that was somewhat naive. In fact, rather than moving forward, we have backtracked since those early days after. We now have a situation where 2/3 of African American children are living in segregated schools.
So what's going to happen with these two cases?
Well, it's hard to know, of course. The court is very evenly divided. Today's oral argument was evidence of that, but I'm hopeful, at least, that the court will recognize that this is actually a relatively easy case because these are voluntary programs that are initiated by local school districts. I thought that that's what conservatives were in favor of, was allowing local schools to make these kinds of decisions, local communities, to decide what's important. And
well, you know what each side is for. Each side is for getting their way every time an issue comes up, and they use their own little bellwether button pushers to solve all their own problems internally. What I'm asking is, where does the law seem to be on this?
Well, I think the Supreme Court has already said that the consideration of race as a factor, not as the factor, but as one among many considerations, is appropriate, certainly in terms of college admissions. We have the Michigan cases, and what's interesting about those cases is that it was an attempt by the court to delineate what is the right way to go about addressing these kinds of racial imbalances and ensuring some measure of diversity in local schools.
Is there a sea change afoot here, potentially, based on the outcome of these?
In what sense?
Well, I mean, is it possible that based on the outcome of the Supreme Court ruling here, that universities, and especially in this case, high schools, middle schools, and elementary schools, could begin changing the way they do business regarding admissions?
Well, I think these are questions that have to be separated. What colleges do is quite different from what local school districts do at the elementary and secondary school levels. But what's at stake here are programs that are actually in place, not just in Louisville and Seattle, where these cases arose, but all across the country. There are literally hundreds of school districts that have very similar programs. They're very flexible. They consider lots of factors. And in fact, in most cases, children are assigned where their parents wish them to be assigned. This only arises, really, in those relatively marginal circumstances where schools that are predominantly white or predominantly black are oversubscribed. And what's interesting is that at least one of the courts of appeals that approved these programs, the Ninth Circuit Court of Appeals, included in its majority one of the most conservative and very respected conservative judges in the country, Alex Kozinski, who essentially said, this is not about racial preferences. This is a rule that's been established that's of universal applicability. And so it provides that, among other things, race can be considered if your school is at a tipping point where it's about to lose the degree of racial balance that reflects the overall composition of the school district.
Good enough, Mark Agrast. Good of you. Thanks for coming up in Studio B, Scotland.